If we could move on, perhaps, to your para 2.8.5. Here you quote the marketplace of ideas in your first phrase, and then later on in the last sentence, the marketplace has also galvanized counteractive measures to combat the spread of deliberate online falsehoods. So I put it to you a few comments, and I would appreciate whether you agree with me. The first is that in those areas where the marketplace of ideas is assumed to be working well and has galvanized lots of measures, whether counteractive or not, in an attempt to combat the spread of deliberate online falsehoods, these measures have not been sufficiently, or if at all, effective. That yes, it may well have galvanized quite a lot of effort, it may have galvanized quite a lot of concern, but that alone has not been effective at stopping the production, spread, virality, and effect of deliberate online falsehoods.
I would first distinguish between factual information and opinion. Where it comes to factual information, I agree with you. It's a deluge that you're dealing with.
Well, let's limit ourselves to factual, right, because that is what we're concerned about.
Sure, no. But this particular paragraph deals with how you want to deal with opinion.
I understand.
And I think the danger is that if we don't make that distinction, it will tilt towards accusations that we are not allowing free expression of opinion. That's our only concern.
But does that not...
Can I say something?
Yes.
Mr. Daniel,
yes.
I think we should be clear about something. We are focused on deliberate falsehoods. I accept your point about opinion. I think, as you would know, and I complimented you on your law of defamation, opinion of any category, however irresponsible, is allowed as fair comment as long as it's based on a substratum of facts. Mm-hmm. And you have identified the substratum of facts. Likewise, opinion should generally not be the target of the law unless that opinion itself is malicious based on facts which you know are false. So the focus of our discussion ought to be facts, and facts which are deliberately false. I think that has got to be the rubric. I accept your point that we should not get into opinion. I think we are on common ground.
Yes, we are.
Thank you.
Okay. I think, let me just... If I could take it to your para 3.2, you are essentially agreeing that there are limitations in existing laws and that whatever steps should build upon and work in concert with the existing laws, obligations, essentially level the playing field and have some coherence with our current standards and our current conduct for all the players involved.
Can I just say something, Dr. Janil?
Please.
I don't mean to interrupt. That is what we're saying in paragraph 3.2. And in this context, I think I should also say that because the submission was prepared based on a collation of different views from the members of the two organizations stated therein, you may not appreciate, or you may have noticed that we don't really go into the remedies involved in the respective instance, because I think remedies will be perceived differently by different stakeholders within this group. But can I just say that in the context of my understanding of the proceedings that have transpired so far, I can understand why an executive takedown regime may be one of the options that this committee will be considering. From my own experience in the copyright field, I have witnessed limitations to takedown actions that we have applied so far. Notice and takedown regimes may not totally remove the scourge of infringing sites. Then you also have judicial site blocking, which is a recent measure. And even though it is a no-fault system, I have seen tireless negotiations over the issue of costs between content owners and network service providers, subjecting themselves to a remedy in court. One would ask whether a takedown regime would work effectively in the context of file sharing, for example, or in torrents, or peer-to-peer. And I do liken, in many ways, the dissemination of DOFs to that kind of decentralized, proliferated regime. And whilst I do understand that executive takedowns would be perceived to be an effective regime, I just want to offer my modest views to the committee that it should not in of itself be a substitute for the vigorous prosecution of the provenance or source of DOFs. I recognize that locating the culprit in jurisdiction may not always be practical, but I think the strongest effective measure to remove DOFs is also to make sure that there is an equally prescriptive and prohibitive consequence for the articulator in the first place. And then I think with that, the combination may yield the outcome that I think we would seek. And this is from experience where if content owners just look at the takedown notices in relation to network service providers as being the short-term solution, it doesn't remove the scourge of, where is the actual culprit?
I understand.
That actually is the provenance. So if you deal with the provenance strongly, you set also a message for everything else to follow in relation to DOF. I just make that comment. It's not really spoken to in the submission, but I think that is a view I would offer committee.
But you agree that the type of executive takedown action that you're describing may have a role to play, but it is not exclusive to other types of action as well.
Oh, absolutely. I mean, I'm not saying that, I think there is I think in addition to that, it's the strongest edict against the actual source, because that is where the trouble originates from, regardless of where you're from. I think having those rules in place would be critical and would actually encourage behavior throughout all the different stakeholders and different layers of content providers.
Thank you very much. If I could just, for paragraph 4.9, it's actually very similar. This is in your summary, very similar to the issue that we raised in your paragraph 2.84, which is about the quality expectation of accuracy for journalists. 4.9 is essentially a repetition of the key points in 2.84. I presume that you would similarly stand by a similar understanding of the fact that we would have high expectations of no inaccuracy from the professional journalist around facts.
Yes, that's right, except that this paragraph goes slightly beyond. Maybe we didn't make it so clear, but there should be a range of remedies, everything from corrections and apologies, right of reply, takedowns, and, of course, penalties if it is ascertained that it's deliberate, intentional falsehoods.
Indeed.
Yeah?
And
so that's what we were leading up to saying. But you're right that we expect the same standards.
so your proposed set of solutions would include some degree of media literacy, some degree of issues with respect to, for example, fact-checking,
Yes.
and then a range of potential regulatory and legislative measures,
Yes.
all of which need to work in concert, none of which individually is sufficient,
Yes.
but taken together may be far more effective.
Yes.
Thank you very much, Mr. Chairman.
So if I may add, regarding the executive takedowns, could I also suggest that in regards to takedown orders, that the respondent be allowed to apply for it to be set aside in all fairness, be given that chance to apply for the setting aside of such an order if it comes to that. And further to that, there should be also perhaps certain grounds in which the respondent can be allowed to set aside that order.
So this was in your
It's not in the paper per se, but I think if we draw from other existing legislation, there are provisions for this.
Well, your para 4.5 does speak to a mechanism for essentially disagreements and dispute resolutions around decisions that are made. So I think the point is well taken.
Mr. Shanmugam?
If I may pick up on the last point, and some of the earlier points, I think really in terms of remedies, based on what Dr. Lai said and what you said, Johnny, is that maybe some sort of a quick, say, executive action to take down, coupled with a remedy to, if the other party wants to challenge it, subsequently to go and take it down, or rather to reinstate it back. But really the quick takedown is essential to deal with the virality and the nature of the digital age, coupled with a range of penalties depending on the, if we can use the term culpability, state of mind of the individual concerned. And that may also then deal with another point that I think Mr. Daniel made, which is that it may have been false, but the person may not have known. And that may then, how you deal with it may be related to what sort of penalties are imposed. I mean, in some cases, if there is no intention, but it is false, it could just be a takedown. In some cases, if there is intention and actual deliberateness involved on the part of the person putting it up, then maybe the range of penalties can be higher. So as long as we are focused on falsehoods or opinions based on falsehoods which are, apparent to everybody, as in, when I say apparent to everybody, what I mean is the opinions are made and everybody is aware what those facts are based on which the opinions are made, and those facts themselves are false. Then what you do is you have a range of remedies depending on the degree of culpability of the person involved. Would I have summarized the viewpoints of the 3 or 4 of you who expressed it on this point?
Yes, you would have, except that I would add that there must be some way in which the party being penalized is given a proper right to.
I think that's the point Juni made.
Yes.
So if
I mean, you may say I'm culpable, but I honestly believe I'm not, and I try to.
I understand.
So there must be some.
So that's why I think it has got to be probably a multi-stage process, maybe where the takedown comes immediately for the first order, and then the person who feels that he is not culpable, or anyway his post ought to be up, may then be entitled to a right of going to some neutral place to have that decided.
I think Juni's point was just appealing the takedown.
Yes.
I'm going one step further, assuming it's been taken down, and whichever authority feels that penalties should be imposed,
yes,
because it was.
I think it follows.
Then it must follow that there must be a due process for that.
Just as he has a right to have the takedown reviewed, if there is any penalty, he must also have a right to have that challenge it appropriately. I think that's I mean, we haven't, sort of buttoned it down to that kind of detail, but that's perfectly sensible and civilized, I think. Yeah.
Thank you.
Thank you.
Minister, can I just add the point that perhaps parallels can also be drawn with innocent publication in the Defamation Act, and how a regime where, if you have, with all the best will in the world, a person acts with innocence in publishing or republishing a falsehood, then an offer of amends can be made. And something like that is I think falls in line with what Minister is talking about in relation to the different categories or the typology of different type of mental state of mind in propagating a DOF. And malice, for example, is another aspect where you either intend to perpetuate the DOF or you are reckless as to the truth or the falsity of the statement that you're making. And that's another form of mental element that I surmise can be extracted to deal with this.
Yes. We will bear that in mind. Thank you very much.